Welcome to Ask the Expert on Contingent Workforce Strategies LinkedIn group. I have a really special topic today, something that you will love, and not only this year, but in time in the future, because we're documenting trends in legal matters and issues around compliance and trends around legal issues and regulations in the contingent workforce industry. And we have the best guest and one of the greatest minds in the legal profession when it comes to our industry in the contingent workforce space. We've got Eric Rumbaugh, who's a partner at Michael Best and Friedrich, specializing in labor and employment work-related legal matters. He's got a national practice scope. He's recognized as an expert in the contingent workforce space, advises on policies, contracts, litigating around, especially a lot of litigation around independent contractors and
You're
temporary
killing
talent.
me, Smalls. Bubba, enough on me.
I know. Okay. So we'll get past this. And he's one of the most humble guys, even though he is very good looking and doesn't like to say that, but I want to say that out loud. And he's nationally recognized, often through staffing industry analysts, as one of the top 100 or most influential minds and leaders in the space. So, Eric Rumbaugh, thank you for taking the time out of your busy schedule today and talking about trends and things happening from a legal perspective and regulatory perspective that we got to be aware of. So, I always start off with like, what's happening out there? You are always in the courts, you're talking to clients, you're dealing with issues that come up, negotiating things. Like, what's happening out there? What are some of the trends you're seeing? One of the more recent situations that you've dealt with? Love to hear your
So
perspective.
let me start with your space. And I
Yeah.
don't think this is the biggest issue, but you deal with independent contractors and
Yeah.
IC classification, and especially kind of the math end of that, the quant end of that. So let me address something that people ask a lot about that lately with the new presidential administration here in the United States. And I don't know how the law flows in Canada from administration to administration. I expect it's very well. My impression is it's very province driven.
It's
Uh,
province driven, like it is in the States, in the US
yeah.
as well, but it tends to be very stable. And just like in the US, I don't think changes of administration change the laws dramatically.
Boom. So that's the point that I want to make.
Okay.
So the Trump administration is less overtly hostile to business,
Yes.
um, and isn't driven by the interests of organized labor. That said, to the extent people think that IC classification you should relax under a Trump administration, that's just not true. Because in every administration, I've been practicing I'm in my 36th year, administrations change, enforcement positions change, but it's never been the case that US federal enforcement is more than a pimple on the back of total enforcement.
Exactly.
States
Yeah.
and much more often private parties drive enforcement through private litigation. So uh, if you think that you can or should be tightening or loosening your program based on who's in the White House, that's just not accurate. That's not good
Yeah.
business. You shouldn't be doing it. Um, you should not be relaxing your IC classification program because Trump's in office, or tightening it up because Kamala Harris is in office.
Yeah.
Uh, that's just bad
Yeah,
business.
because there's so many different um, agencies and levels of government that are involved, and they come from different perspectives as well
And,
and different tests.
and I would also say the Trump administration just rolled out new proposed regulations governing the analysis of who's an independent contractor. And I would say that this time, unlike previous Trump and Biden efforts to promulgate rules, they're actually going through the rulemaking process instead of just saying, this is the new rule because
Yeah.
I'm the president, I said this is the new rule. They're actually trying to go through the process. But even if they go through the process and the rule takes effect, one, they'll have a year and a half, 2 years left of the Trump administration. So it'll change again. Second, it's never going to be a law. It's still going to be a reg. It'll be
Yeah.
worth whatever weight a court wants to attach to it. And third, and here's the biggest problem, the biggest reason why have, I would not let changing U.S. presidential administrations drive my business model. The fact that the feds say something in almost all states isn't going to influence what the state does.
Correct.
So your biggest risk if you're running a national program isn't the federal enforcement, it's private enforcement and state enforcement. So yippee, you're great under federal Fair Labor Standards Act, but does that mean you're okay under the Illinois Wage Payment and Collections Act? The answer is certainly not.
Yeah.
The Illinois Wage Payment Collections Act is where programs go to die.
Yeah.
It's
Or
overtly,
California, or
unapologetically
you name
hostile.
it, right?
And so do not, your problem has always been private enforcement, and the having good federal compliance doesn't say anything about state or local compliance.
Correct.
So my answer is you should know what the feds are doing. You should read their new regs. If we had 3 more hours, we could talk about my analysis of the new regs. But at the end of the day, that shouldn't drive your program. And compliance with that doesn't mean you're compliant. So that's that point. Second complicating factor is almost all states and almost all circumstances are going to apply state law based on where the worker's sitting, when she or he's doing the work. And with so much more of the workforce being mobile and being
Correct.
remote, another side problem is your worker remote? Are they working in Colorado? Are they working in Texas? Are they working in Tennessee?
Yeah.
Are we complying with Colorado law? Didn't know we had to, didn't know he was sitting in Colorado. So remote workers being in places where you didn't know they were, that's a separate problem, probably beyond our scope. But that's one of the people say,
well, and that's one of the more important things to think about. And it's just as a nugget of gold, I think that we're just going to hit on here is a lot of organizations and individuals don't understand that the laws apply where the work is being provided, not where it's being received. So if you're a Texas-based company and your manager's sitting in Texas, it's not Texas laws being applied, it's New York State laws being applied if your worker's sitting in New York.
There's a couple of exceptions to that. There's a Washington state tax that's based on where the work was received.
Yeah.
But in almost all cases, it's where the worker's sitting. So problem number one is you don't have as much control as you think you have over where the worker's sitting, and you probably don't have as much of visibility, forget about control, as to where the worker's sitting.
Yeah.
Than you think you have or than you need. So that's a problem. But I'd say the biggest problem facing employers generally, and maybe even disproportionately employers in the contingent workforce space, is the substantial and mushrooming patch quilt of local laws.
Yeah.
Running a national program, if you ask anyone who's running a national program, whether it's direct hire or a staff aug program, your biggest problem is being in compliance with the patch quilt of local laws. You're going to have a paid leave program, but you might have 45 different local paid leave laws that don't agree with each other.
Yeah.
You're going to have a workplace training program for human trafficking, for workplace violence, for heat, for sexual harassment, for disability discrimination, whatever. And you want to have a program, you're using EEOC guidance to have a model program, but the state of Illinois wants you to show their video. State
Yeah.
of California wants you to show their video. Um, so running training programs, running workplace safety programs, um, uh, administering paid leave programs nationally is devilishly difficult. And so
Yeah,
what I
there's a
say,
complexity to that that is really hard to solve unless it's very systematic, right?
and systematic might be your enemy. We're
Yeah.
following our system, but the
System didn't have the local law built into it.
yeah, I have a client who says something. I'm gonna rephrase what they say. They say the law isn't in compliance with our model. Um, City of San Francisco's ordinance isn't in compliance with our business model. City of Portland's ordinance isn't in compliance with our business model. And how do you, it's all but impossible to run a national program and comply with all of these local um, ordinances,
Yeah.
state, county, municipal laws and ordinances and enforcement positions that are not consistent.
Yeah.
So here's my counsel to people who are running a program or buyers of people. When your HR compliance group says, "Hey, we need help," they're not lying. Get them additional help. And if
Yeah.
that means budget of hiring another person, they're not lying. They need another person because it's a lot.
Yeah. Well, it is, and that's like bringing it back to uh, our situation in the independent contractor realm. That's the complexity that needs to be solved because you're just in the US alone. There's 50 different states, which are 50 different laws. You've got the Fed, then you've got the worker comp regulations, which tends to be even different. So you multiply things
So
by two,
workers
three
comp.
times just in the independent contractors laws alone. Then you get into all the other workplace safety, health and safety, EOC, and all of that. You can multiply it not only even at the, like you're saying, at the it's the federal or state level, it's now even the municipal ordinance
Yep.
level.
And
It's just another layer, right?
that was true 12 years ago,
Yeah.
15 years ago. You would start to see Philadelphia, San Francisco, different municipalities have paid leave laws that if you've got a worker who's working in San Jose but comes into San Francisco 12 hours a week, San Francisco would try and get you to prorate paid leave based on how many hours the person was in San Francisco. How can you run a railroad that way?
Yeah. It's impossible.
You can't.
Yeah.
It's just, I mean, it's metaphysically possible. We could do it, but it just doesn't scale.
Yeah.
You're saying don't do business here, is what you're saying. Can we be efficient? Can we be profitable doing this? The regulatory view is don't know, don't care, not our problem. And if you've got four different municipalities telling you to do it differently, how are you supposed to run a business that way? Again, the people who are promulgating these rules, their response is don't know, don't care, not our
Yeah.
problem. So you're dealing with business hostility at the regulatory level, and I'd say that's the biggest problem facing every program, direct hire and contingent, is this patch quilt problem. And
Hmm.
then we talked about remote work. You have to comply with the law where the worker's sitting. I want to address another. You say, what's keeping me awake at night?
Yeah.
Another problem that comes up increasingly, and I think it's a tip of the iceberg situation. I haven't seen any national studies on this, so I don't know how anecdotal my experience is or how common it is to other people's experiences. But people are holding multiple jobs
Yeah.
and lying about it.
Yeah.
So you got somebody who's working for you, and they've got four other full-time jobs at the same time, and they don't know about each other. I got seven wives, and
Yeah.
none of them know about each other. I got seven jobs,
Yeah.
none of them know about each other. And with using AI, using telework, remote commuting, people are able to get away with it a lot longer than they would have been able to get away with it even 5 years ago.
Traditional employment where you physically had to show up to places. Yeah.
So a cousin of that we're seeing is I get hired for a job. I've got the resume, I've got the the experience to do the job. I interview for the job. I get hired for the job. I'm not. So one problem is I'm spoofing who's applying for the job. So I've got a fake resume,
Yeah.
and you hire somebody who's a fake person. But that's a problem. Different problem is I'm a real person. We can shake hands. We can meet in real life. We can
Yeah.
have coffee. We can talk. You can love me. But the guy who shows up to do the job looks vaguely like me, but isn't me. And so I'm getting 17 gigs around the world based on my resume, but I'm not actually doing the work. People who are showing up at the Zoom meeting aren't me.
Yeah, and they're keeping the
And
camera off, or they're just, or they do, and they
or they
whatever,
look
right?
vaguely
Yeah.
like me,
Yeah.
and but they're not me. And so what's my game on this? The people who are actually doing the work can't legally work in whatever country they're doing the work in.
Gotcha.
They don't have the correct visa status to work in France or the US or wherever they're working, but I do, and I'll get them the job. They can get the consulting gig in Mexico City, or I can get the consulting gig in Mexico City, and I can have my friend Jeff, who looks vaguely like me, actually show up to do the work in person or by Zoom.
Yep.
And I could have 17 people as proxies out there doing work for me. I get paid $200 an hour. I'm paying them $20 an hour each, and they're doing the work for me.
Yep.
We're running into that over and over. So people holding multiple jobs and concealing
And
it,
is
or people showing
what is
up.
the complaint on that? Is that wage theft essentially, or is
Well,
it?
it's fraud.
Yeah.
And
Okay.
if they're designing a widget and the widget breaks, who do I sue? Um, am I negligent? You know, can the person actually do this job? Are they licensed to do the job? Are they qualified to do the job? It's a big quality control problem.
Hmm.
And in some cases, let's say I'm a bank. Let's say my client's a bank. I'm seeing financial data.
Yeah.
Let's say the entity is a healthcare company. I'm seeing PHI, and
Yep.
I'm not authorized to see it. So there's all kinds of security, data privacy uh, reasons to be concerned about
Who's
this.
liable in that case? The employer for hiring someone that is not legitimate, or the person themselves for being fraudulent in representing themselves to be able to do the work and has somebody else doing it?
Yes,
Everybody.
well, at least potentially liable. Yeah, I mean, I'm
Hmm.
not, you as a general matter, you're only liable if you're negligent. So if you do a reasonable good faith investigation into who you're engaging and they lied to you, it's them, not you.
Yeah.
But your client isn't going to love you if
No.
you were diligent but wrong.
Yeah.
There's just going to be uh, smear all over all of us.
Yes. And how do you like in the world of temporary work and contract work, a consultant can have multiple roles and often
You need them to if you're going to classify them as an IC.
correct. Yeah.
If you've got an IC and you're their only client, they're Tom Hagen and they've only got one client.
Yeah,
Uh, that's a problem.
there's a dependency there.
Yeah.
But in the case where they're going for a full-time job, generally in that employment relationship, they're they're putting in their 40 hours a week, right? If they've got a side gig over here, is that okay? Or is that they're moonlighting at something they shouldn't, right?
Well, okay, so that's an interesting question. There's a small but growing number of local laws that ban anti-moonlighting provisions.
Hmm.
So if you want to moonlight, I can. It's none of your beeswax. Um, Most of those, as far as I know, all of them have a carve out for things that would constitute a conflict of interest. So
Yes.
I'm a real estate broker for Acme Real Estate. Can I also broker for Jones Real Estate? Well, who am I going to give the good listing to? That's a
Yeah, yeah,
conflict.
yeah.
So, but um,
it becomes an interesting dynamic around that because, yes, you say it's fraud, but in the world of work today, where it's moving towards more and more contingent workers, that as long as it's honest, I guess,
Well,
to
okay.
say, listen, I'm going to put 20 hours in at your work, I'm going to put 20 hours in here, and I'll put it 20 hours in at this other client of mine.
Look at it this way. If I'm paying for your time
Yeah.
and you're selling 240 hours a day, that's fraudulent.
Yes.
If I'm paying for your deliverable and I get the deliverable, I don't care if you churned out 6 deliverables today or 16 or one a week. It's none of my beeswax. I got my deliverable and it worked and I paid for it.
Hmm.
But if I'm paying for your time and you're like um, the producers, you're selling 30,000% ownership of this play, uh, uh, then I care.
Yes, exactly. So it's almost impossible to find this out, though, in this world of
It's
remote work.
and I have found that when our clients are finding this out, they're finding it out en passant.
Hmm.
That was my French Canadian shout out to you. Um, you're finding out in passing. There's not a good way to check to see if somebody's got 6 other gigs while they're working for you.
Hmm. Because
And
they're
again, if they're
working
an
on their
IC,
own
you don't.
internet connection typically at home, right? They've got two laptops potentially. Um,
If they're an IC, you want them to have other
you
gigs.
want them
That's
to.
what
So
makes
it's an
them an
interesting
IC.
dilemma. The idea of the statement of work, where you're doing milestone-based work, where you're kind of, I don't care as long as I get what I want done, go for it, right?
And I
We're in this kind
want
of weird transition of work because you're seeing the freelance platforms really start to take off. We're seeing more and more of them i- coming into programs that are either proposing statement of work or very much globalization of the workforce. And I think we're moving towards that trend. We're nowhere close to it. So we're getting this mindset of the individuals to say, how can I get away with it and do multiple jobs at the same time? And then the employers are trying to catch up and enforcing this. But would it be better to just say, hey, listen, I'm not going to be your full-time employer, but that's not realistic for every job in an organization. But there is a potential solution where you say, get your work done. I don't care. As long as I'm not buying your hours, I'm buying your milestone.
If I'm buying your deliverable, I don't care.
Hmm.
And I also don't care if you do the work yourself or farm it out to 2 or 4 or 17 people.
Yeah,
I got my deliverable. Unless I do care. So I may have contractually agreed not to subcontract.
yes.
That may be in a federal acquisition regulation clause that I've signed on to in my contract with my client.
Hmm.
So I need to have you deliver the widget and not farm it out to somebody else. Not
Correct.
because not for any business reason, but because of a contractual reason that I've agreed to.
Yeah.
So um, only
So
insist
what
on
are
it if
some
you
of
need to.
the ways people, like you said, they're catching it kind of on a passe after the fact? They're finding out either just from a sense and then they do some investigation around it. How are some people starting to implement it so they can find this out up front? Are there identity management tools? Is there like
Well, there's a
skills?
lot of tools that are similar to tools to catch people cheating on exams, remote
Mhm.
exams. Like you have to have a camera behind you and a camera in front of you, so we can
Yeah.
see if there's someone behind you telling you how to answer. So there's a lot of interview techniques that are like that, catching people in the interview. But if you are confident that the person you're interviewing is the right person, you hire them. Are you going to do that every time they show up at a Zoom meeting?
Yeah.
How do you know they're the ones showing up at the meeting next Tuesday?
Yeah.
So anyway, it's look, I'm not saying that's the biggest problem. I'm going to say with a bullet, the biggest problem programs face is the ubiquitous and growing number of local laws that you have to comply with.
Yeah.
It's uh, it was a problem 10 years ago, and it's 70 times worse now.
Yeah, because every municipality, every state either has a change of administration and the next people in think, oh, we got to do something, and they update it, or they are administrating or governing by news cycles. So something happened in the news, and they change the regulations around things, thinking they're doing good, right? For the most
Simple,
part.
look, and maybe they are, but the fact that their good is different than Shelbyville's good is a problem.
Yeah.
Shelbyville's trying to do good, Springfield's trying to do good. They're both well-intentioned, good things, but they're different from each other. And I have people working in both Shelbyville and Springfield.
Yeah.
That makes it hard for me to run a program. Now, if I've got 70 different cities that I have to deal with different rules, that's you get to the point where it's just you have to throw up your hands and abandon
Yeah.
all hope, ye who enter here.
Well, and it goes back, I guess if I was to I'm just thinking through, and we're brainstorming a little bit here, but it goes back to almost that reliance on localization partners, right? Partners that understand those local rules or are up to date with those rules, and you can rely on them to be your partners to act in those rules. So
Well, okay,
take a
so
contingent program, right? If
that's necessary if you're dealing with nation states.
yeah,
So if you and I are going to run a program in Bulgaria, there's a roughly 0% chance that I'm going to give legal counsel on how to comply with Bulgarian law
correct. Yeah.
or Canadian law for that matter.
Yeah.
So I've osmosed a decent amount of Canadian law,
Yeah.
as you know.
Yeah.
I still don't understand the three-line pass rule, but uh, um, I guess if we're a man short, we're allowed to do three-line passes. But other than that, I don't fully know Canadian law. Not
Yeah,
fully.
so
I
you
don't know
would
Canadian
you
law
would
well
look
enough.
to localized counsel to help with those
Right.
things.
But our law firm, like I think every large law firm in this space, we have uh, a service where we tell clients monthly about all the new laws in their
Yeah.
space. And every law firm does that because you have to. It's a full-time job for a bunch of people at our firm keeping track of that.
Yeah.
Imagine I'm a procurement office in a company that makes widgets, and we got 7 people in our office. Who's going to keep up with new Tennessee law, new Arkansas law, new Florida law,
Yeah.
new Oregon law? Really? You can't. Now you're gonna have your law firm give you this stuff, but now you have to look at your program every month and say, okay, what do we have to change to comply with this new set of rules?
Yeah. So you are correct when you say your HR compliance group needs more funding, but it's also partnering with your legal, who has good external legal partners that monitor these things, can update legal or update the HR groups of these changes, and then plug those into the
That's
systems you
that's easy
have,
to
right?
say. That's a
Yeah.
hard thing to do on the ground.
100%. I guarantee, 100% I know that. 100%. Like, are the ERPs that are there or HRIS systems, they're not flexible enough to, or nimble enough to allow for this?
I wouldn't say that, but it still takes a human being in the loop. But I think the answer is they are if they are.
Yeah.
I think they can be, but it's a
Hmm.
big lift for them too.
Yeah. Well, and that's where that idea of to systematization of this makes sense, so that if those updates happen, you it's almost like a software update, right? It's the legal update goes into the system and those new rules get put into it. Once again, easier to say than actual practice of it. But there's some thoughts around that from a
I, I,
systematization of
I
this.
I had a situation, this is a different era, but maybe 20 years ago, we had a client that um, was missing, had missed a number of garnishment orders in a particular state. And they might have had thousands of employees in that state. And they missed enough that a court sanctioned them in a really public and painful way.
Yeah.
And we hadn't been doing that area of law for this client, but the client came to us and some other law firms and said, "Hey, how much to handle this compliance piece for us?" And the rule is you can never make a mistake again because just got sanctioned. We've been threatened with really bad sanctions if we ever make a mistake again. Wow. And so we were offered a bucket of money if we could take charge of compliance, but the contract term is you just have to tell us you're never going to make a mistake. And I said, we can't do it.
Yeah.
We're going to handle a couple thousand transactions a year, and I'm going to promise you that no person's going to make a mistake.
Yeah.
Can't do it.
No, because there's even if you're monitoring it, there's always a chance of a mistake happening. Yeah.
Machines make mistakes, human beings make mistakes. If you have enough transactions, you're going to get mistakes.
And that's why there's audits that happen at a point in time and then rectification of those audit findings afterwards.
But even with that, even if you had 3 different law firms auditing and then auditing the auditors and auditing the auditors of the auditors, you're still going to make mistakes if you have enough transactions.
100%. That's true. So it is very difficult to even systematize this patchwork that you're talking about.
You can and you have to.
You have to, though. That's your best practice.
You can and you have to, but realize it's a big lift. Realize it's become nearly Sisyphean, and give it the attention and the resources that it needs. Take it seriously and realize as soon as you get it done, you have to push the rock back up to the top of the hill.
And it's interesting because, being in the compliance space too, part of it is the status quo, the inertia, let them catch me attitude, right? To move things forward. It's usually the people that get caught that are the best customers to lawyers and best customers to compliance tools that help them be more compliant going forward. But in saying that, right, why do you see that, and are you seeing some trends to people being more proactive? Why is compliance and governance sometimes on the low end of the priority list?
I'll give you an example from an industry that you started off in oil, right?
Yep.
So go back 15 years ago when oil was first over 100, or 20 years ago when oil was first over $100 a barrel.
Yep.
And everyone in the oil industry was day rate IC.
Yep.
And nobody wanted to be the company that moved people out of day rate IC classification, because these people are making you money, and that's how they want to get paid.
Yep.
So if you pay them in some other compliant way, we're compliant, but we're not making any money.
Yeah, because the workers don't want to work for you.
Right.
Yeah.
So there's no prize for compliance if you're out of business. So the whole industry operated in a largely, or not the whole, almost the whole industry operated in a largely non-compliant way because they didn't have an option. If we're the one person that's out of lockstep with how this industry works, we could pat ourselves in the back for being compliant, but we're not going to have any of the talent.
Yeah.
So it gradually moved, but
you still see a lot of independent contractors working in there.
And they could be independent. They could be. I'm not saying that they're not legitimate independent contractors. Yeah. The day rate's a problem.
It was a huge issue, and still is. Yeah.
And so you say, why would that happen? Why would compliance take a back seat? And the answer is, look at all the money. The money is laying on the ground. Can you see the money laying on the ground? Our job is to go pick up the money. It's laying there. If we don't pick it up, someone else is going to go pick up. We're going to go pick up the money.
Yeah.
So it's situations like that where compliance will take a back seat.
Yeah. Until you get caught.
And I would say the workers had no incentive to challenge their classification.
No.
The money's laying on the ground for them too. These are not victims being misclassified.
No.
These are beneficiaries being misclassified.
Yeah.
If
Well,
they're
and
if
and we're
in the
seeing
cases
that in
they weren't all misclassified, but in the cases in which they were misclassified,
yeah.
they are not just willfully, giddily misclassified. They can't cash the checks fast enough. They're getting paid so
Yeah.
much money. The $2,000 a day day rates were common, especially
Yes.
for offshore people.
Yes. And so being treated an independent contractor also helped them probably from a taxation perspective as well. But if you're not structured as a legitimate
Say it again.
independent contractor, it doesn't help you when you get audited, right? It's interesting. The individuals are also at risk when,
Not at much risk.
yeah,
I the I have talked about and Cassandra about uh, the risk of your ICs getting audited and then it bouncing back at you. In thousands of cases, I don't remember that ever happening.
yeah,
So it's the business is much more likely to get audited than the individual.
100%. That's because
Maybe
it's an aggregation
100,000%
of
more
that.
likely.
What we have seen in higher personal tax rate jurisdictions, Europe and in Canada, we have seen that happen. They've gone after individuals heavily. They call them personal service businesses in Canada, where they've reclassified their income or the revenue that they had through in the US would be their LLC, which is an incorporation in Canada. And in Canada, small business tax rates are 1.5%. Personal tax rates over 150K is 5.4% in a number of provinces. And so high income earners like to set themselves up as small businesses. But the government, if they look at it and they look like, they smell like, they act like an employee, will then reclassify the income that they brought through their little company as personal income and assess personal tax rates. And that hurts.
15 to 54 is a big delta.
It is. So in the US, you don't see as much of that because there isn't as great tax rate differentiation, right? So, um,
Well, if you have an LLC, it's just a tax pass through.
correct.
The
So,
LLC isn't getting separately taxed.
correct. The only difference in the US is their write-offs in the small business, but you could
Well,
do that in under
also,
your SSN number too as a sole proprietor.
and you might say that payroll taxes would be the delta, but if you're self-employed, you're paying self-employment tax,
You
which is a
should be.
proxy for payroll taxes. So it should be about a push in the
Yeah.
US.
Yeah. Getting to health and safety, is there in the world of health and safety, OSHA, worker comp issues, are you seeing litigation, any trends in health and safety issues, litigation around personal injury that is popped up, or any changes in regulations?
Well, there was the big hullabaloo about heat regulations over the last 2 years. But I'm not seeing a big workplace safety driver.
Hmm.
I mean, early in my career, really early, this is me late 80s, early 90s, I did a turn at our firm where I would go out to the place of uh, immediately after a serious injury or fatality. And I don't want to go back to do that job again. That was a hard part of my job.
Yeah.
But I just don't do that much of that anymore. But I don't think so. It's in my department, but it's not something that I do. I
Yeah.
don't, and I've never handled an OSHA criminal case.
Yeah.
The police show up, but I've never handled an OSHA criminal case. So, but I don't think that there's been any big movement in that over the
Yeah.
last 15 years from where I sit. If there maybe somebody who does that every day would say, Rumbaugh, you're wrong. They'd say that anyway, and they'd be right. But here, I don't.
Lawyers like to debate anyways, but you haven't seen major changes in regulations or enforcement or anything like that.
Well, workers' comp is all local,
Hmm.
and I think it's pretty stable.
Yeah.
It's a no-fault law almost everywhere. Whose fault it was that someone's got injured doesn't matter. The worker gets paid, their medical bills get paid, and in a staffing context, it's the staffing supplier's workers' comp insurance that pays, and the staffing supplier and their client are both co-employers, so they're both immune from most tort claims.
Yeah.
So you actually want workers' comp to come and play if you're a buyer or a supplier, because then you pay a guaranteed fixed amount, and the lawyers generally don't get involved.
Yeah. Well, and getting back to the independent contractor, it has been fascinating the data we've been collecting on folks coming through the process, and they'll have business insurance, so professional liability or general uh, liability, but they won't have the worker comp.
Well, you can't, if you're a single shingle, there are states where you can't buy workers' comp. The
Understood.
state would view you buying workers' comp as a dodge for you to get around paying health insurance.
Hmm.
So there are states where a single shingle consultant, independent contractor can't buy workers' comp for themselves.
Correct. But there are a lot of states that you can.
There's a lot of states where you can, and so a properly drafted contract requiring workers' comp won't say, and you'll buy workers' comp. It'll say you'll buy workers' comp to the extent required or permitted by law,
Yes.
because that way you're not immediately out of compliance the day you sign the contract because you can't buy it in Michigan.
So in a situation where it's a state that they can't buy workers' comp, who covers the worker comp of the proprietor of that independent contractor
They don't
business?
have worker. Well, okay, so that's an interesting question. If in fact they're nobody's employee under that state workers' comp law, then the worker would pay their own medical bills and there'd be
Hmm.
no workers' comp coverage.
Hmm.
Now, if they're injured, they could then turn to their client or a third party or whatever and say, you were negligent
Yeah.
and you have to pay my medical bills. And so there will be tort litigation. In a workers' comp context, rarely is there tort litigation.
Hmm.
Almost
Because it's
never.
covered by worker comp.
It's covered by workers' comp, and where workers' comp coverage exists, that's your exclusive remedy. So
And so in
you
as a
can't sue your
best
staffing
practice,
company or the client for negligence because you got workers' comp and that's it. Now, if I get injured in your factory, I could sue Acme Widgets that made the machine that I was injured by. If it's a products liability situation,
yeah,
they're not my employer, they made the machine. That wouldn't be barred by workers' comp exclusivity. But
gotcha.
I couldn't sue the company that's running the machine because they were my co-employer in
Hmm.
most cases.
So in independent contracting, in those situations, would you still be able to get a private policy and have that
Private health,
small business
like
have worker comp?
like a commercial general liability policy? Sure,
Yeah.
the answer is yes.
Mhm.
And if I'm hiring you as an independent contractor, I would want you to have insurance to cover injury.
100%.
Workers' comp to the extent you can buy it, and CGL to cover anything else.
Hmm. And so
CGL,
that's
commercial general
general,
liability.
but it's fascinating. We don't see a lot of employers mandating that. We
So
recommend
I
that, but
I
they aren't
want
mandating that.
I want businesses to require insurance from independent contractors for two reasons. One, it's a business relationship. Your
Hmm.
business partner should have insurance. Pitfall. If you have a insurance clause for vendors and it's the same for everybody, it's necessarily not appropriate for everybody.
Yeah.
So you've heard me say one of my best risk management tools for running a program is periodically meet with your broker and say, here's who we've got doing stuff. We've got these people classified as independent contractors. We've got these people as employees, but employed through some vendor, a employer of record or a staffing firm or whatever. And then here's our direct hires. This is what they're doing, and these are the insurances we have in place, and these are the insurances we're requiring from our vendors. Do we have a hole in the bucket? Is there something we're missing?
Yeah.
And are we requiring too much here or not enough here? Is there a rider we need to cover this activity? So you should have that discussion with your broker and find out. And I'd show them your insurance clauses, your paragraph 11 in your contract with your independent
Yep.
contractors, your paragraph 15 in your contract with your staffing supplier, and say, this is what we're requiring. Are we requiring too much or not enough? And the answer is going to be yes.
Yeah,
In
it will
some
be.
cases, you're
Yeah.
requiring too much. In some cases, you're requiring not enough. And the perfect thing would be to particularize the insurance you're requiring based on the risk that you're facing. Programs
Always.
don't
Yeah.
like to do that because that takes time and thought.
Yes.
And so you do a guns or butter evaluation of, okay, do we want to, is it worth the squeeze to actually think about case by case what insurance we're going to require, or is it better to just have a one size fits all insurance clause, realizing we're overreaching in some cases and underreaching in others? However, coming back to your question, in the context of a single shingle independent contractor, I still want to ask them for insurance because independent contractors have opportunity for profit and risk of loss. If they have no expenses, how can I argue that they had a risk of loss? What if their only expense is a laptop? And we make you use our laptop because we don't want to have a bring your own device policy, which creates data security risks.
Correct.
So
Yeah.
now there's one expense, and we've taken that expense away from you.
Yeah. Yeah.
So now, how do I argue opportunity for profit, risk of loss? Answer: the gift, the solution for all seasons is make them have insurance,
Correct. It's an
not as a
ongoing
device to
expense
make
they
them
have.
ICs, but
Yeah.
because it makes business sense.
Yeah.
But don't give them your Johnny Bravo one size fits all jacket. That was my Brady Bunch reference for this.
Don't give them the typical staffing supply, large staffing supplier
Actually,
requirements of 10 or 15 million, which is not needed for an
spend
independent
spend
contract.
something north of 0 minutes thinking about what insurance we want you to have, but don't have it be nothing, because if they have no other expenses, you're going to be glad that you had them have insurance.
Well, and then the triggering event of a misclassification lawsuit is usually something that potentially has liability, right?
It's well, so
And if
I would say
insurance
that
covers it, like workers' comp, all of a sudden that misclassification question goes away because their worker comp policy is covering it.
yes, although somebody will have incentive to challenge
Yeah.
coverage if in fact the person wasn't an employee or
Yeah.
wasn't eligible to get coverage. If it's a big claim, if it's $1.5 million claim, there will be something north of zero people checking to see if, in fact, yeah, we issued this policy, but should we have? Was the
Yeah,
person
that's
actually
that's the
eligible?
insurance business.
Yeah,
That's a whole other story there. But I get it. There's the two sides of it. It's risk mitigation just from claim covering claims that have potential liability. But what you had said, it also helps with their independent contractor status because they've got ongoing costs and expense that could cause a profit and
yeah,
loss
and I
situation.
would warn, don't be glib about this.
Hmm.
There were, uh, I can't remember if this was Biden or Obama guidance. I think it was Obama era guidance on IC classification that was talking about looking at expenses and was cautioning about artificially inserted expenses for this purpose.
Correct. Yeah.
And I've got that guidance dog-eared and highlighted somewhere in my desk.
Yeah.
If you're gaming, you're coming up with, let me back up. You should not insert an expense just so that you've got something to point to for IC classification.
Yeah, no, it makes sense.
For
And
a
insurance
business
is a good
reason.
one, though, because it's also mitigating a risk of the small business if there was a claim.
Correct. And especially if the only expense they've got, but the other one of you've heard me, if that's the only expense they've got, then you need it. Especially if you're not going to allow people to bring their own device, and the only thing they need is a laptop and a phone, and they're not, they have to use yours. Another place. This is I'm digressing a little bit, which I never do. I never digress, but I'm going to make an exception for you, Mo Prayer. Is don't if you want someone to be an IC, wean yourself of reimbursing their travel expenses. Don't pay a per diem. Make them buy their own plane ticket. Make them buy their own meals. Make them pay for their own hotel room and their own rental car. And if you think that you're not paying it, if you think that's going to chase away vendors, then up their comp rate.
Correct.
And make them go to their own pocket to pay expenses.
Yeah.
If you insulate them effectively from expenses, you just insulated them from being ICs.
A documented proof, and that's something. And we got to probably cut this off at some point because we're in that hour range. We're getting past that, but it is been an incredible conversation. But that whole idea of having documented proof to help an attorney defend you in a misclassification is probably one of the most important things. So if you don't have documents, it's he said versus she said, and it's hard for you as Eric, who is one of the top litigators in this field, to prove a point.
We can't make bricks without straw.
I love that. And I think that is going to be quoted in whatever comes out of this conversation. We can't make bricks with straw. And that is important.
Without straw.
Yeah, without straw. So it's really important to.
That was also my Passover reference. This
Happy
Easter.
Eric, this has been fantastic. So we got to cut it off at some point. But there is so many nuggets of gold in this conversation that the audience will be able to take away from what trends are happening, some best practices around independent contractors and other issues. But that the takeaway is really start to understand that quilted patchwork of laws and start to really identify that and help as best you can put in systems to help identify them and mitigate them best you can. But I can't thank you enough for the time we've spent.
My pleasure. It was a free for all.
You got it.
That'll be my Ted Nugent reference for part with.
I can never get off the phone with you or a call without a Ted Nugent reference. So I thank you for our friendship as well.
We're a full service law firm. Be well, Jeff.